Any mentioning not in the list? Any mentioning in the list? Item number 1. There are 23.
I will for the state, my lord.
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
My lord, the case in the nutshell is that the petitioner is a MTA staff, a subordinate staff under the DC South Andaman.
Okay.
And the accused person, the respondent number 2, is the subdivisional magistrate and IAS officer.
Okay.
Now, my lord, the date of incident, it's a allegation of physical assault by the SDM upon your petitioner. Complaint was lodged before the officer in charge, SHO Aberdeen Police Station. Initially, complaint was not entertained. Subsequently, my lord, 156 clause 3 application was preferred. Direction was given. Case was initiated. Now, lordship, thereafter, lordship, the police report submitted as a lack of evidence, lordship.
Okay.
Now, lordship, I preferred an application under 173 subsection 8 for further investigation. Lordship, initially that order was in my favor. The learned magistrate passed an order. The running page number, lordship, the order of the learned magistrate initially is page number 65, where the learned magistrate has been pleased to direct for a further investigation. In the nutshell, what the learned magistrate observed, that the investigating officer did not interrogated the attending witnesses, attending doctors by whom the victim was treated, and also investigating officer never interrogated the victim and his wife. It was the primary observation. Subsequently, my lord, on that ground, further investigation was directed. Now, during the course of the further investigation, my lord, the report submitted by the investigating officer is moreover a replica of the report which was primarily submitted in the initial report of the investigating officer. What development had happened here, my lord, that my wife and I was examined under section 161 CRPC statement was recorded, from which the major thing of the offense which come unearthed, my lord. What happened, my lord, on the date of incident, 25th of August 2021 is the date of incident, at around 6 to 6:30 p.m.
Okay.
Now, my lord, on 26/08/2021, on 26th of August 2021, the morning, I visited my office to complain the matter before the superior authority, because I was assaulted by my superior authority. The highest is the DCSA. Thereafter, SDM assaulted me. I fainted over there due to the pain, due to the injury I suffered last night. I was taken to hospital. I was admitted. I was treated. Subsequently, my lord, my wife in the evening visited the local police station, lodged a complaint around 6:30 p.m. Subsequently, at the night, 9 p.m., two of the staffs of the office, under the instruction of the DCSA, which is admitted position, which come up from the report itself, that yes, they were instructed to see the health condition of your petition. They visited at 9 p.m. at my residence. They asked my wife and my mother to come to the DC office at night and to talk with the DCSA. My lord, I went there to lodge a complaint, further complaint on the DCSA. Now, they tried to persuade me to withdraw the complaint. Now, my lord, To that effect, a written letter was also drafted by one of the witnesses, one of the perpetrators, I will say. They are all in the conspiracy, Lord. That letter, my lord, is the annexure P70, page number, running page number 76, P5. My lord, the last document I have annexed. Now, my lord, very interestingly, the investigating officer getting this document have interrogated the person who have written this, Niloy Rai. During interrogation, while recording the statement, he have not put any question to him that who have written this. But the investigating officer have recorded statement of another two witnesses, asked them, do you recognize this handwriting? They say, no, we know the handwriting of Niloy Roy, but this is not his handwriting.
Okay.
Lordship, the admitted position is they have visited my place, they have taken me to the DC office. What conversation was held, they don't know with the DC and my wife, the victim's wife. But this is admitted that they have visited, and I went to my wife was persuaded to visit DC office. Now, my lord, my respectful submission is on the earlier report as well, the London magistrate could consider on its merit and directed further investigation. 3-4 points, not, I will not put, my lord, into very intricacies of the factual aspect, my lord. 3-4 points. One is attending doctors. They were not, their statements were not recorded. Till today, their statements were not recorded. In this report, it has been mentioned by the investigating officer that they are not presently posted at their position as they were in erstwhile. They are now transferred to some other places. Therefore, they could not be examined. Although their statement could be gathered over telephonic conversation and over email. Now, my lord, the 14 of the witnesses who were examined by the investigating officer, their statement did not come up front, my lord. The two attending doctors, their statement have not been recorded and not been placed in 161 statement of the list of, my lord. If I trouble your lordship to come to page number.
What is the order you have challenged?
Lordship, the order, concluding portion of the order is, lordship, page number 74. The magistrate passed an order. Investigation was done in this case twice. This is the observation of the London magistrate. In both the cases, the respective IOs submitted that no case against the accused has been established. In the second Naraji petition dated so-and-so, the petitioner agitated mostly the same allegations. Those were agitated in the first Naraji petition dated so-and-so. The IO has investigated the case thoroughly. I think there is no need for any further investigation of this case. In view of the above facts and circumstances of the case, I am inclined to reject the prayer of the petitioner for further investigation of this case, Lordship. Now, no observation, no reasons has been recorded by the London magistrate that why he thinks that there is no necessity for proceeding further against the accused by ordering a further investigation, my lord.
So doctors were examined or not?
Not examined, lordship. Moreover, the CCTV footage, lordship, which has been recorded, CCTV footage, the investigating officer said, page number 70, lordship, the order sheet, it reflects, so lordship be pleased to see once page number 70. It starts from 69, the last line of the 69, page number 69, lordship. What the CFSL told after perusing the data, page number 69.
Yes.
The CFSL sent their report on which they mentioned that the data from the hard disk marked HD1 was not extracted as the hard disk could not be detected by the available tools of the laboratory. Now, Lordship, this is the grey area, Lordship. Now, Lordship, the CFSL do not possess the requisite tools. Now, Lordship, that cannot be a ground that no incident has happened, Lordship. When the attending doctors as well, they have not been examined. And Lordship, the handwriting has not been sent, that the note, that the written handwriting of withdrawal letter, Lordship, that has not been questioned to the person who have allegedly written, or that document has not been sent to the handwriting expert to see. That is the crux of the case, Lordship, because he is an influential person, he is an IS officer. It is very difficult and hard for me as a MTS Group D staff to fight against him, to lodge a complaint against him.
Yes, yes.
Now, Lordship, he pressurized to withdraw the letter of complaint. To that effect, a person sent by him was instructed. He written it for me. I have submitted the same before the investigating officer. Investigating officer acknowledged the same, but not sent it to the handwriting expert for verifying that whether the handwriting matches with Niloy Roy or not. Another last thing, Lordship, I will submit, if your Lordship permits me, a audio recording. When I was present in the DC office, the recording between me, Prabhakar Rao and Niloy Roy, who visited my place for persuading me to withdraw the complaint. That recording has also been supplied to the investigating officer, but that has not been taken into record, and that has also not been sent to CFSL for verifying the same, Lordship.
Yes.
My lord, I'm just representing the state. I don't have much to indulge in, because it's a matter between the applicant and the honorable court. He's challenging that order of rejection
Yes, yes.
passed by the Leonard CGM.
This is a motion, only motion.
My
So,
lord, the London magistrate initially directed for the investigation, then again the matter was investigated, and again the FRT was submitted by the police, and that has been accepted by the London magistrate. Giving a reasoning is there, my lord, that exhibit P4 is the reasoning as to why that FR has been accepted,
okay, okay.
and that may be.
Very well.
Your
Please
my
take
lord.
down.
I cannot hold the brief of respondent number 2
I
as a
understand.
private respondent, because if the case is met out, then he will become an accused and we will prosecute him.
The Instant Criminal Division has been preferred against an order dated 28th of August 2023, passed by the learned Chief Judicial Magistrate Court Blair in connection with GR case number 53 of 2012 of 2021, corresponding to Aberdeen Police Station case number 72 of 2021 under section 332 stroke 353 stroke 325 stroke 326 323 330 332 353 325 326 379 506 of IPC. Stop. Next para. By passing the impugn order, the learned Chief Judicial Magistrate has rejected the prayer of the petitioner for re-investigation. Or the learned advocate peruse the materials, also peruse the impugn order passed by the learned impugn order. Stop. considering the submission of the learned advocate for the petitioner. And also considering the submission of the learned advocate appearing on behalf of the state, the petitioner is directed to serve upon the private opposite party number 2 regarding the copy of the application along with the annexures thereof. Let the matter appear through registry. Through registry. No. Through registry. Through registry. Stop. Let the matter appear in the next available circuit. The state is directed to produce the case diary.
My lord, only one indulgence, my lord. My lord, that it will be not reinvestigation, lordship, further investigation. I have prayed for further investigation.
Further investigation.
And lordship only
On the adjourned date.
I will provided with the liberty to file certain documents with a supplementary affidavit, lordship, if your lordship pleases, lordship.
Petitioner at liberty to file supplementary affidavit along with some related documents, if any.
Grateful, lordship. I'm grateful. Shall be deeply obliged, lordship.
Item number 2, Sierra 19 of 2023.
My lord, I am appearing for the petitioner, my lord.
For the statement.
Here, my lord, the case is, my lord, we are medical officer homeo. There are two applications, second and third. We have been appointed to the said post on contract basis way back in the year 93-97. Since then, we were working up to 8th of March 2022 under the medical department. Now, my lord, in the year 2002, there was a purchase committee promulgated by the Directorate of Health Service, in which we are also a member. Now, my lord, the thing is that the purchase committee was consisting of Ayurvedic doctor and homeo doctor. So whenever the purchase is made for homeo doctor, homeo medicine, we would be the technical person to assist the said purchasing committee to what is the requirement, what everything, requisition, everything will be put by us, and on the basis of the technical advice by us, the medicines will be procured. Similarly, for the purpose of Ayurvedic medicine purchase, there is a technical person. On the basis of his technical advice, that is the doctor, medical officer, Ayurvedic medicine will be purchased. Your Honor, my lord, during the period from 2004 to 6, Ayurvedic medicines were purchased on the basis of an advice of Dr. Rajesh, who is one of the member of the purchase committee and the technical person, because he is the Ayurvedic doctor in the said committee. Procurement were made. When this procurement were made, subsequently, my lord, it was found in the year 2012 that such procurement were made on the basis of the technical advice by Dr. Rajesh at an exorbitant rate, and the supplier are his family members. The farms which are there belongs to his family. On the basis of that, in the year 2012, an FIR was initiated by the anti-corruption unit. The moment the anti-corruption unit initiated the FIR against him, because he was also working on contract basis as Ayurvedic doctor, that's why he was in purchase committee.
Yes.
So, my lord, a so cause was issued to him, followed by his termination from service in the year 2013 January. Now, my lord, all along we were working as medical officer homeo, and yearly extension was given on the basis of the appraisal which was given by the competent authority with regard to the discharge of service by us. Now, my lord, on 30th of March 2021, a charge sheet was filed by the investigating agency, wherein, irrespective of the fact whether we are at all involved in the said criminal offence which is described under section 2N of the CRPC, my lord, charge sheet was filed only because we are a member of the purchase committee. Now, my lord, from the charge sheet, I will show, my lord, that there is no allegation against us, and whatever submission I have made, that this is the technical person, and on the basis of his technical advice that was procurement was made, it is apt in the charge sheet itself. Now, my lord, so far as petition number 2 is item number 2 is concerned,
Yes.
the allegation is that she was in a comparative statement, she also put signature. Item number 3, there is no allegation at all. Only because he is a member of purchase committee, he was added. My lord, I will just place the charge sheet first, my lord, only the relevant portion. My lord, kindly come to page 26.
No, this is a motion stage. So
No, my lord, I am paying for quashing. There is no, in criminal matter, my lord, quashing, my lord, quashing of the charge sheet against me.
I understand whether
My lord, in criminal, my lord, we argue and the court pass the order. This is what, there is no question of.
CD would be available here.
No,
CR is to be.
CD is that
LCR.
is within a half kilometer from here.
LCR is maybe called.
No, LCR is not required. It is only charge sheet. There is no evidence where led. It is only charge sheet, my lord. If my lord so please, my lord may call for the case diary from the IO. That can be done because it is till date charge was not framed.
Very well. Charge was not framed.
No,
So what you
I am challenging the charge sheet. Caution,
Charge
caution.
has been submitted.
Yes, my lord. Even my lord, CD is not recorded, but it's comments to my lord where it can be done. But my lord, let me place the facts first, my lord, from the charge sheet.
No, if I want to hear the matter, then I have to see the CD.
My lord, my lord,
So both the matter 2 and 3,
my lord. One argument will do, my lord.
one argument or two. So please take down
Tomorrow, my lord.
tomorrow. You bring the CD tomorrow. Is it possible?
My lord,
It is just nearby the court, my lord.
2 days time.
Monday.
2 days time.
Monday.
Monday.
Very
Not Monday, my lord, there are other cases, maybe on Tuesday.
No, my lord. My lord, kindly appreciate. We have only 4 days left in the next week. Then it will be difficult. My lord, the charge sheet is there. My learned friend can call at any point of
Fixed on
time.
Monday. Let it fixed on Monday. If it is not available, I will hear you on Tuesday. No issue.
Monday, my lord,
Do you have any difficulty on Monday?
there are cases fixed for lengthy arguments are there in those.
My lord, let me place my case. My learned friend may give reply on Monday or Tuesday, my lord. I am just because I will
just
not
want
take
the CD only. Just
and my lord, I will not take more than 10 minutes, my lord. I will just place the because of this, my lord, I have been thrown out from service. I approached the tribunal and I approached the High Court. Both says you contest the criminal matter, then only it can be renewed. My lord, kindly come to page 26, my lord.
no, I will hear the matter with the CD. Without CD, it cannot be.
My lord, my lord.
This is a decision application under section 482 of the Code of Criminal Procedure for quashing a criminal proceeding. A criminal proceeding initiated against the present petitioner in special case number 88 of 2021 under section 8 of 2021 under section 13 within bracket Roman 1D stroke 13 Roman 2 under the Prevention of Corruption Act 1988. Read with section 418, 420, 120V stroke 34 B stroke 34 IPs. Stop on hearing the learned advocate for the petitioner, it appears that the CD of the instant case is required to be perused. Accordingly, the state is directed to produce the CD on the urgent date. Let the matter be urgent today. List the matter for hearing on 17th
17th,
Tuesday.
30.
Okay, come on.
Brilliant.
Let it be 70. Let it be remaining in the same position. Both the matters. Item number 2 and item number 3. 7.
Very wonderful.
Item number 4, you 15 of 923.
I'm for the opposite party's plaintiff.
Yes.
My lord, the respondent herein filed a civil suit before the Learned Court of Chief Judicial, Learned Court of Civil Justice Senior Division at Port Blair for partition of the suit property
Yes.
for her share, claiming her share. And along with that, she also filed a petition for injunction order 39 Rule 1 and 2, which was rejected primarily by the Learned Trial Court. Assailing that order, the respondent approached the Learned District Judge. That was turned down initially. Then the respondent approached this honorable court, and interim injunction was granted for a limited period, and there was a direction upon the Learned District Judge to dispose of the matter expeditiously within 30 days. Accordingly, the matter was remanded back with a order of stay till 30 days. Hearing was concluded, and then the Learned District Judge was pleased to pass an order of stay in favor of the respondent herein and against the petitioners herein, with a direction to the court below for expeditious disposal of the civil suit. Assailing that order, I am before my lord. My lord may kindly come to the order first, my lord, which is at page number 72. May I take my lord to the operative portion? My lord may kindly, it starts from page number 72. My lord may kindly come to page number 79.
Yes.
Last second para from the bottom in the middle. Admittedly, the appellant is one of the legal heir of R. Dhanraj, but the scheduled property has been recorded mutated in the name of respondent number 1. The respondent number 1 is the petitioner number 1 herein. That is the mother of the appellant and respondent number 2 to 4. It is the case of the respondent. The appellant, along with her 3 sisters, gave consent before the Tehsildar at the time of mutation, and appellant at the time relinquished her share in the property left by her father R. Dhanraj. Once the appellant relinquishes her right in the property, she cannot claim any right, title, and interest in respect of the suit property. Going to the records and also the document available, it appears that the balance of convenience and inconvenience is in favor of the appellant, and at this stage, when she pays for partition and declaration of right, title, and interest in respect of the suit property, and the said question can only be decided after conclusion of trial. Taking into consideration the document produced by the parties to the suit being titled suit number in respect of the suit property at this stage, this learned court is of view that if the appellant be not given any protection and if the respondent number 1 is allowed to go on construction until result of the suit filed by the appellant in the court below, she will suffer irreparable loss and injury. Since the appellant filed the suit for partition and declaration of right, title, and interest in respect of the suit property thereof, in my point of view, the appellant is entitled to protection at this stage of proceeding. In result, the misappeal succeeded. Now, my lord, may I place the backdrop fact of the suit which was filed by the respondent before the learned trial court.
Yes.
My lord, the fact of the suit is like this. The property initially was recorded in the name of father of the respondent herein, husband of petitioner number 1 and the other petitioners. What has happened later on, my lord, after the demise of the father, this particular respondent, I'll bring attention of this honorable court towards the document also. This respondent approached the Tehsildar Blair with a request of mutation of the land suit property. Petition was filed in the year 2009 by this respondent, wherein the signature of other petitioners were also there. The landed property was solely mutated in the name of mother, and all the petition number 2 to 4 and the respondent gave their undertaking in form of affidavit that they want the land should be mutated in the name of mother. Accordingly, the land was mutated. In the year 2021, the mother started construction in the suit property. 4 flats were constructed. Kindly take a note of it, my lord. This is very vital and important. 4 flat was constructed. It is there in the plaint that it was agreed that the share of the plaintiff is agreed by the mother. 4 flat is for one of the respondent and other 3 petitioner from 2 to 4. The mother, being the petitioner number 1, she did not construct anything for herself. She decided to reside with the younger daughter, that is petition number 4. When the building come up completely, respondent petitioner number 2 to 4, they did their housewarming. Till that time, there was no hue and cry from the part of this particular respondent. The moment they tried to make an attempt to enter in the said constructed house, stay order was passed and then we were restrained to enter the house. Now, my lord, may kindly come to the document once. My lord, may kindly come to page number 23 of my petition, annexure P1. Got it, my lord? Page number 23. This is the suit property, my lord, 3173,207 square meters. It was initially recorded in the name of R. Dhanaraj, husband of petition number 1 and father of petition number 224 and respondent herein.
Yes.
Thereafter, my lord, may kindly come to page number 25. In the year 2009, in the remarks column, it is mentioned, my lord, the land was recorded and mutated in the name of petitioner number 1, the mother of respondent in petition number 224. Got it, my lord? In the remarks column, it is mentioned that TPB RC number 1863 2009, the land was mutated on 12/1/2010. Got it, my lord?
Yes.
Now, my lord, may kindly come to the document at page number 27. This is the letter addressed to the Tehsildar folder, which was diarized on 4/11/2009. At the top, my lord, seal is there, which is written by the respondent herein, Vijay Lakshmi. Kindly see at the right hand bottom. She wrote a letter for mutation of landed property in favor of my mother. Thereafter, my lord, next page, my lord, page number 28, Form J and Form K was issued in favor of all the legal heirs. My lord, may kindly turn back to page number 28, wherein signature of all the respondent and petitioners appears there. Got it, my lord?
Yes.
Thereafter, my lord, kindly come to page number 30. This was the first affidavit sworn by me, declaring the legal heirs. Next is the affidavit at page number 31 of Vijay Lakshmi, the respondent herein. Third is the other petitioner. Similarly, 33, page number 33, affidavit of another petitioner. And page number 34, petitioner, another petitioner, petition number 4.
These are the no objections for mutation.
Yes. Then thereafter, my lord, page number 36 is the revenue order whereby the land was mutated in favor of the petitioner number 1. Order by the Deputy Tehsildar Podlar on 12/1/2010. Got it,
Yes.
my lord? Thereafter, my lord, may kindly see the building plan, which is at page number 37. I applied for the building plan being the recorded tenant, which was sanctioned by the municipal authority. Got it, my lord?
Yes.
In the year 2022, it got sanctioned. At point number 5, my lord, may kindly see, it is on 3rd March 2022 to 2nd of March 2024. Thereafter, my lord, surprisingly, my lord, may kindly come to page number 42. This is the rent receipt. My lord, after the house wherein I was residing in the suit land, the entire house was demolished because it was an old structure, and then the new structure come up after the construction. During those periods, I, being the petition number 1 mother and the recorded tenant of the land, was residing in a rented premises. This is the revenue rent receipt which I used to pay during those periods. Now, being the owner, being the mother, and at the outset, I can, with the greatest of the respect, my lord, I would say I am ready to give her share. One of the flat in the ground floor I have constructed completely, only the interior work was not done. which was agreed by her initially, is left vacant. Other three flats, the interior was done, furnished, everything, housewarming, puja was performed. Only we need to enter the house. No further construction is required to be done in that flat. But then we have been stopped by the order of the district judge. Now, my lord may kindly come to next page number 43. If my lord will calculate the sum which I have paid and invested for the construction, it goes near crores. First receipt at page number 43, it is of 20 lakhs to the contractor. Next receipt at page number 44, it is of 10 lakhs. Next receipt at page number 45, it is of 10 lakhs, my lord. Another receipt at page number 46, 15 lakhs. Then at 47, page number 47, 4 lakh 30. Page number 48, 5 lakh 70. So these all was the payment, and there is no case of the respondent herein or the petition number 2 to 4 at any point of time that they invested even a single rupee for the construction of the house. Now thereafter, my lord, kindly come to the plaint which I have enclosed at page number 30 of my petition. Page number 50, I beg pardon. Page number 50, I beg pardon.
Is this explained?
Plain. My lord may kindly come to page number 52. Page number 52, para number 7 and 8. That in the month of, got it, my lord? That in the month of May 2009, defendant number 1 and 3 approached me to sign certain paper for mutation. That believing the same, the plaintiff signed the paper and handed over the same to the defendant. Now this is the turn back for the plaintiff in the suit. That in the month of November 2009, the plaintiff received a notice from the Tahsildar.
Plaintiff is the one of the daughter of the defendant number 1.
Petition number 1 herein.
Okay.
That in the month of November 2009, the plaintiff received a notice from the Tahsildar Podla for mutation of the scheduled property. That the plaintiff along with the defendant appear before the Tahsildar Podla accordingly. Now both these statements, both the contentions are contrary to each other. At para number 7, she says that we were made to believe that it is a joint mutation. She signed the document. At para number 8, she says that at November 2009, she received a notice from the Tahsildar. She appeared there. This suit is barred by limitation, my lord. At the first instance, I would say that in the year 2010, the land was mutated. In the year 2022, she come up for a suit. Now thereafter, my lord may kindly come to page number 53. Para number 11. That in the month of October 2022, when plaintiff went to meet the defendant number 1, the plaintiff asked about the document of the mutation in order to apply for subdivision of the scheduled property. Upon that, the defendant number 1 told that defendant number 1 will share the property equally amongst the plaintiff and the defendant number 2 to 4 after constructing building upon the scheduled property for which the plaintiff does not have to do any work for same. The plaintiff agreed for the same, and the defendant number 1 also told the plaintiff that she will sell another property which is in the name of defendant number 1 to construct the house in the scheduled property. And for the same, defendant number 1 requires some time. The plaintiff believed the word of defendant number 1, agreed for all the claims put forth by the defendant number 1. Plaintiff told the defendant number 1 to inform the same to the defendant number 2 to 4, in which the defendant number 1 told the plaintiff that she has already informed the other defendant. Now the question is, where is the suit then? If the respondent at the plaintiff itself admits that in the month of October 2020, when she approached the petition number 1 herein and the defendant number 1 before the lower court, and she agreed that she will give the share after construction of the building. Now, where is the case, I'm asking myself, and the entire building is constructed, my lord. At the worst, we can consider if the trial is taken up, but the question fall back again before this honorable court is that, will the trial court pass any order for demolition of the structure and to give her share of 40 square meter? Wherein the entire investment is made by the petitioner number 1, being the mother. Now, if that is the fault on the part of petitioner number 1 to give a flat to all the daughters after putting all her money, then I am deserved to be out of that building before my death. If that is my fault, I do agree, my lord. Now, my lord may kindly come to the learned court below. I must say the learned, my lord may kindly come to first the order at page number 70 of the Honorable High Court. Now, single judge passed the order. that is on 26 April 2023. The petitioner has filed the present civil revision application being aggrieved and dissatisfied with the order passed by the Learned Civil Judge Senior Division. Entitled suit number 35 of 2023 dated 74/2023 and the order passed by the Learned Appellate Court in Miss Appeal 3 of 2023 dated 20th of April 2023, wherein both the Learned Court will have rejected the prayer for grant of ad interim injunction, temporary injunction. The petitioner has filed the suit for partition with respect of the suit property which actually recorded in the name of father, and after the death of father, the suit was mutated in the name of the wife of deceased R. Dhanaraj, instead of mutation in the joint name of all the legal heirs. The Learned Civil Judge Senior Division, while rejecting the prayer of ad interim, has held that the plaintiff has not filed any document to show that the father was the owner of the property, but it is the found from the record that the plaintiff has annexed the record of right issued by the Tehsildar, wherein it is revealed that the land was recorded in the name of R. Dhanaraj, and after the death of father, the land was only mutated in the name of wife of deceased instead of all the legal heirs. Without going into the further merit of the case, kindly take a note of it. This court finds that both the court failed to consider the document filed by the petitioner, and as such, the order passed by both the Learned Court below are set aside, and directed the parties to the suit to maintain status quo as on date, and the parties are further restrained from making any construction over the suit property till the disposal of the appeal. Learned District Judge is directed to dispose of the appeal as early as possible within a period of 1 month after reopening of the court after summer vacation. This was the order. Now, my lord, may kindly see one more thing, that in the month of October, as per the plaint, the respondent approached the petitioner number 1, the defendant number 1 before the court below. By that time, the construction was going on, my lord. The suit was filed in the month of April 2023. Kindly see the intention of the respondent herein. We never denied that we are not going to give you any share. Now kindly come to the photographs I have enclosed, my lord. Kindly see all the interior works of the flat.
What is the order? To maintain status quo.
Yes, to maintain the status quo. To maintain the status quo.
So why you are aggrieved? You are not in possession?
My lord, I was in the possession. Only thing is, after the housewarming was done, the puja was performed. On the next day, when we were supposed to enter the house, we were restrained by the police of PS Aberdeen, because the daughter of the respondent herein is a constable in the police department. Taking the garb of the order of Honorable High Court, in the month of April, we were restrained to enter. My only humble submission before this Honorable Court is that, my lord, that there are 4 flats. 1 flat is left vacant. Let that be decided after the trial. We have completed all the interior works. We have invested all the money. We only want to enter, will not do any further construction work. Because, my lord, directing the lower court to conclude the trial within 6 months, I don't think practically it is possible. We want to see the allegation was that we are taking up the construction. We don't want to do any construction. Everything has been done completely.
So who is in the possession of all 4 flats?
It is now under lock and key.
All 4.
All under lock and key. But we have, like the other petitioners, they have completed their interior works. Now, if we don't able to clean also and reside there, it will get worse by day. It will get damaged. Because my lord knows, if a new house is constructed and then nobody is residing out there, even if the assuming for the worst, my lord, if tomorrow if the judgment comes in favor of the respondent hearing, it will be to the tune of 40 square meter, 45 square meter, if I'm not wrong, subject to correction. But then no court will say that to demolish the entire building and to hand over 45 square meter to the respondent hearing, so that she can enjoy to it. Because 1 flat, kindly see the photographs, 1 flat in the ground floor is left vacant, and the flat.
No, how many flats are there?
4 flats.
Only 4 flats.
4 flats.
Not the position, so I'll argue.
There are only 4 flats. 3 of them for petition number 2, 3, and 4. 1 is for respondent number 1.
So what is the effect of the order of status quo?
I'm not able to enter the house.
No one is able to enter the house.
No, they have not invested any money.
No, I understand.
I invested the entire money. I invested the entire money. It was out of my money. The fate is that, my lord, at present, being the owner of the land, I am residing in a rented house. I am residing in a rented house. Kindly appreciate that. I have enclosed the rent receipt also.
So what you want to enter into on flat?
I want to enter in a flat. Rest let them be, there be a order that there will be no interference with the other flats. Assuming for a moment at the worst, my lord, if tomorrow the Learned Trial Court says that I am supposed to give 45 square meter of land to the respondent, will the court allow for demolition of the entire building and to hand over the 45 square meters of
This
land?
is the suit for partition.
Shoot for partition. We are ready to
What
give one flat.
structure is there?
No, we have constructed the structure.
Let him complete, bro. Let him complete
The structure was constructed by me in the entire suit property. So there is 4 flats. Initially, it was agreed by the respondent that she will take flat in the ground floor. The moment the building is completed, we have conducted the interior works. Now she wants the flat in the first floor, and she is not ready to pay any amount for the interior work done by us.
This is the dispute.
This is the dispute. Now kindly see the photographs. In one photograph, the petitioner number 1 and the respondent is there. They are performing the Dwar Puja of the flat of respondent number 1. Respondent, sorry. The difficulty is this, my lord, that at this stage, wherein I am a senior citizen, I have constructed for my entire family 4 flats, but I am restrained to enter the flat. And I am residing in a rent house.
So what is your prayer now?
I pray, my lord, that I may be allowed to utilize one of the flat, at least. Because I have invested the money, kindly see the money receipt out there. There is a law of limitation in the year 2009. It is admitted in the plaint that she got. My lord, my lord. But at least being the investor, being the original tenant, can there be a stay against the original tenant? I am asking myself. Can there be a stay order against the original tenant is the question before this honorable court.
Yes, Mr. Jaipal.
Lord, let's not guided with the sympathetic. Supreme Court said no sympathy view. Lord, it's a partition. I'm a daughter. Lord, the modus operandi of the mother and my sister is I got married. I'm residing somewhere else. They had this much lump sum. They have not even a courtesy to get the property partition, because under the local regulation, which is prevailing law, most regulation of 1966, partition is permissible. Now they say that I have given no objection for mutation. Lord knows the position of law. These documents neither to create title nor extinguish title. I have, if there is any document as such, there has to be a release date. That is not here. Mutation was done, and Lord knows the effect of mutation. It's for a fiscal matter. Who have to pay land? No, there is a entire land they raised palatial building comprised of 7 rooms is one part. They want to, the argument was advanced in such a fashion to show their bona fideness that they are in a very clean hand. My Lord would say in these buildings at the corner, which is comprised of 10 to 15 square meters, even not my share, they want to give it. That to show to the society and to this court that they are very clean with this. Not they have invested the money, they said, they have obtained plan and not on that. Rather, these documents are to be thrashed out in the suit. It's a matter of trial, not injunction scope is very limited. One has to show that prima facie case is in the favor of plaintiff or not. At the first instance, identity was refused. First appellate court refused. I see the hardship which my client suffered on 26 April 2023. A coordinating bench of this court held that both the court has committed error. Documents were not considered. What was the document? Document showing that the suit land was held by our predecessor, Dhanraj. It's an undivided property, not. The shares have yet to be determined. So when the matter was remanded back to the district court, the balance order was passed. Maintain status quo. Suit has to be concluded within 6 months. When the order was passed, and while passing this order, materials were considered. The materials which the other side is now trying to demonstrate before the court were duly considered. Because what most appellate court is the last fact-finding court. It considered the material primarily for the purpose of consideration of injunction application, and status quo was that to maintain with regard to nature cabinet position. And one of the very interesting part is, it's not that the suit was kept in animation suspended. No, the trial court was directed to get the suit expedited within 6 months. These matters which I argue, which the advocate argued, needs to be gone into by way of evidence, whether I am right or the other side is right. As of now, prima facie case has to be shown. Prima facie case is it's an undivided property. I am a co-sharer. Not most the series of judgment. Each co-sharers have right over every inch of land. Be it 1 square meter, be it 0.1 square meter. It's big, not 40 square, not a simple thing. Let suit proceed, not. The judgment which they have assailed was passed in the month of June 2023. They filed a still revision, not time see, when they filed after 4 months. Instead of putting the pressure upon here, they could have proceeded with the suit. Not by the 2 months, it could have been the civil judge senior division not nowadays fix the schedule. In High Court time bound matters, I do the civil matters there. I know in High Court matters, time bound directions, schedules are fixed, consecutive dates are fixed based on the directions. And not the first appellate court have passed the correct order. These matters, whether I have invested, from where I have got, whether I'm having a room, whether I'm having a rented house, these matters are a matter of trial. It's an arguable case, I would say. I would say these are the arguable case. Whether the building can be partitioned, whether I'm entitled to get overdue amount, these things need to be gone into by the trial court. Limitation, not partition suit, I have just heard for the first time, there is any limitation. Unheard of. There is no limitation for partition suit. Every day is counted, 22 is limitation act. It's a successive recurring cause of action. And I would frame lordship, this is a fit case where the trial court can decide the entire issue. Who is suffering, who is undergoing hardship, and rights need to be determined first, Lord. It's an undivided property. I'm again saying, Lord. My giving no objection to my mother to get the land property mutated, I have not foregone my right. There is no extinguishment right. It's merely for a mutation. There are several judgments. So I would frame lordship. Lord, I can make one submission. The submission would be instead of now also lordship. Instead of 3 months, 3 months, even within December it can be done. WS has already come on record. Issues needs to be framed lordship, by schedule has to be framed. Let's go with the trial of the suit, Lord. I'm a daughter, Lord. I have a share. It's not that I've been excluded from this co-personal property. Which flat I would take, which flat they would take, we are not there to decide it, Lord. The court would decide. I would frame lordship for rejection rather dismissal of the application. And no interference may kindly be made, Lord. So it's a partition suit. Other suit I don't understand, Lord. Hardship, those things come into play. Because I have a share over it on every inch. It's my humble prayer.
Yes.
May I just give a short reply, Madam?
Only on law conscious policy.
I am not supposed to learn from you, please.
Facts and all, everything has been
This is a
done.
judgment I am relying on.
Here,
My lord, may kindly have a look to this judgment I am relying on. This is of year 2008, Supreme Court 2291. Injunction granted of suit for preliminary decree for partition and possession, consecutively decree for permanent injunction restraining respondent from alienating or construction on property was also sought. Prima facie respondent in possession of the property in suit for a long time. Appellant never exercised any act of possession during pendency of the suit. Used construction come up on disputed land cannot be directed to be demolished, at least at this stage. One of the respondents said to have spent 3 crores of rupees. Thus, in fact and circumstance, it would not be proper to stop further construction in the interest of justice. Respondent allowed to carry out construction of the building subject to ultimate decision of the suit. Now, my lord, regarding prima facie case, balance of convenience and irreparable loss and injury. This is a judgment which I'll place, my lord. I'll take the printout and I'll place it before my lord. 1993 AIR Supreme Court 276. Dalpat Kumar and others versus Prahlad Singh and others. It says like this: grant of temporary injunction principle thereof, duty of the court. The phrases prima facie case, balance of convenience and irreparable loss are not retroactive phrases for incarceration, but words of wit and elasticity to meet my rate situation present by man in ingenuity in given facts and circumstance, but it is also hedged with sound exercise of judicial discretion to meet the end of justice. Now, the court has, the Honorable Apex Court has categorically mentioned, my lord, what is irreparable loss and injury and how it is to be looked into. In the present scenario, if I am not wrong, kindly correct me if I am not wrong, my lord, the prima facie case, I can demonstrate before my lord that since in the month of October 2022, when they get the knowledge, they acquire the knowledge, why they took around 8 months to come and file a suit? By that time, they allow the construction to go on. Irreparable loss and injury. I being the owner, rightly or wrongly, a mutation is recorded in my name. Whether they gave the NOC, whether they have given the relinquished deed or not. But then, my lord, it is stand record in my name. At present, I have constructed flat out there, but I am residing in a rent house. Who is suffering and who is giving irreparable loss and injuries? It is me. Balance of convenience and inconvenience, again, it is in my favor. I am asking for a single flat to get entered into the flat. I'll place this judgment, my lord, just within 10 minutes. I'll give to the court.
Yes.
But those two judgments, judgment is an authority on the point which is decided. Those judgments are upon full-fledged trial. Here trial has not even commenced. So I would say these judgments would not applicable in the present.
It is under Order 39 Rule 1 and 2. The order was passed and it was assigned to Honorable Apex
You
Court.
give me the judge.
So I don't think it is trial.
At the
Even I
moment,
know a bit of civil.
I am reserving it. You give me
My
the
lord,
judge.
I'll give the copy.
At the learned advocate for the parties at length made clear.
Okay.
Item number 5. 053 of 33.
Expedite disposal of this suit. Where is that? Lord wants to serve the notice, I will do it, but we should not prejudice the other side. Partition.
What is the stage?
Partition.
What is the stage?
The stage is at the responsibility.
2000.
Once it was ex parte, thereafter certain interlocutory applications were filed. Then section 10 application is filed, the order is awaited. Originally,
Whether WS has been filed by
it has been filed.
by all the parties.
Yes, I have against the WS also. But kindly turns to page 28 by defendant number 5. Only this defendant number 5 has filed the written statement.
All the defendants which appeared, I think.
Yes, but they have been filing an interlocutory application under section 10, saying that it can't be maintained. But only the defendant number 5 has filed it. Yes.
By 2024.
As well.
Please take down. The instant civil revision has been preferred for, no, this is an application under section 227 of the Constitution of India and Article 227 of Constitution of India for an innocuous prayer for speedy disposal of the title should be number
18 of 19.
no title should number. What is the number?
Their transfer code number is TS 107 of 18. Transferee code number is Joint Civil Justice TS 18 of 19.
TS 18 of 19.
19.
Pen 18 of 19. Pending before the learned Joint Civil Judge Senior Division. 14. Stop. It appears that the title suit was filed in the year 2018 initially. Thereafter, it appears that the instant title suit was filed in the year 2018 initially. Thereafter, it was transferred to the learned trial judge. The suit was preferred for partition and declaration. Stop. And for cancellation of the alleged will.
Yes.
declaration for cancellation and for cancellation of alleged will. Stop. The learned advocate for that petitioner submits the necessary direction to be made so that the suit may be disposed of as early as possible. Not the learned advocate peruse the prayer. It appears that the notices is not required as the prayer of the instant revision is revision shall not prejudice the other parties to the suit. Accordingly, the instant CO 53 of 2023 is disposed of with the direction that the learned trial judge, that is Joint Civil Judge Senior Division, Port Blair, shall dispose of the suit within December 2024. 24 as the affidavit of affidavit of opposition. Affidavit in opposition is not exchanged, so the allegations made in the petition shall deemed to have been not admitted. CO disposed of. Disposed of.
Item number 6.
In this, my lord, I am for the petitioner. Yesterday, I received a CAN application from my brother, Binu Kumar. So I'll be using my objection to it.
For adding me as a respondent, because the order which was challenged, that order was passed in my favor.
I am not aware. I have to consult with my client, so I pray for next circuit so that I can use my objection to that CAN
So
application.
CAN application was filed.
My
Okay.
lord, my brother has filed CAN application yesterday.
Please take down
I also want to file my affidavit in opposition.
affidavit in opposition against the CAN,
No, not against the guy.
against the main
Main writ petition.
writ.
Let it be open if there is something.
Yes,
Let it be open if there will be something in can, then we can also collect. We have to consult.
okay. The CAN 1 of 2023 is filed by the who filed the
My lord, page number 2, my lord.
page number 2.
National Union of Seafarers.
National Union of Seafarers of India and one another. Stop. Let the stop. The petitioner is at liberty to file affidavit in opposition in respect of the CAN. You are for the authority. The respondent authority is also at liberty to file. Respondent authority is also at liberty to file affidavit in opposition against the CAN as well as against the main writ application. Let the matter appear in the next available circuit.
My lord.
Item number 7. WPN 960 of 2023.
Here I am appealing for respondent.
I appeal to the petitioner. This is the matter where I said that I applied for sale permission, which
Yes,
has been rejected without assigning any reason.
My lord, sir. I have taken the instruction, my lord, sir. My lord, sir.
what is your instruction?
My lord, sir, page number 2, my lordship. My lordship, may kindly have a look in page number 2, my lordship. Here, my lordship, the ground is that, my lordship, there is a case, civil case is pending. OS number 90 of 2010 before the Honorable Civil Judge Senior Division, Port Blair. Due to such reason, this was not issued, my lordship.
Whether there are any injunction?
That has to be verified, my lordship.
No
This is the present.
injunction.
What is the report?
The worst part is that your lordship, I am not a party to that suit.
Whatever may be, whether you have stayed
No.
That has to be seen from the civil section, my
Then
lordship.
you
That-
got the report. Report is not appropriate.
This is the report, my lordship.
This is report is not appropriate.
Yes, my lord.
You take the report,
They have not.
Yes, ma'am.
published
Proper report.
the reason, nothing, and now coming with the paper saying.
My lordship,
that there is
I will verify from the lower court record, my lordship, whether any stay is
No,
not
you-
there or not.
you file with the affidavit.
Yes, my lordship.
You file with the affidavit.
Yes, my lordship.
Okay. So please take down. What is the title suit number?
90 of 2010.
90 of 2010, my lordship. Other suit?
Where is the number?
In second line,
OS
90 of 2010.
Civil Judge, Junior Division, Port Blair.
Senior division court, my lordship.
Senior Division Court. Very well. The report of the authority contains that one suit being other suit number 90 of 2010 is pending before the learned civil judge, Senior Division Port Blair, in respect of the self-same property for which the sale permission was denied. It is not clear whether any order of injunction or stay was there. According, order of injunction or stay was there in the suit itself. Accordingly, the authority is directed to file affidavit stating the fact that whether there is any stay for disposal or alienation of the property in question by the learned civil judge, Senior Division Court. When you would be appearing?
2 weeks, my lordship.
2 weeks, lordship. The problem is that,
Come on Thursday, last day.
yes.
My lord, I think it is not possible. I have to receive parawise comments from the concerned department.
Appearing that particular suit, I find out. They are appearing in the.
But I have to see who is the
Yes,
panel advocate appearing. I have to see. Your Honor.
Fine.
No, no.
He's appearing. I have seen.
No, I am not there, Your Honor.
He is the one who is appearing and he doesn't.
Might be other panel advocates are there, Your Honor.
Very, let,
He is the one who is.
No, I am not there. If it is
Let it
there,
go Wednesday. Yeah.
okay, come on Wednesday.
Wednesday,
Come on
right.
Wednesday. Come on Wednesday. Okay, if it is available, then, okay, the authority.
steps in it.
The authority is to shown before this, shown on or before, no, the authority shall come up with the affidavit. Shall come up with the affidavit on 18th.
18.
Release the matter on 18th.
Yes, ma'am. Oblige.
Oblige.
Report filed by the authority be taken on record. Report filed by the authority be taken on record. Next. Item number 8. Yes,
The rest all matter may kindly be released. for-
yes, released. Rest matter released. Yes, I want to hear this. Yes.
My lord, before I place the citations, I would just like to bring forward 3 particular documents for the perusal of this honorable court. The first document happens to be at page number 31. that is marked as Exhibit 4. My lord, it was marked through PW1 at page number 3. My lord, may kindly come to page number 3.
Yes.
Page number 3, from bottom it is 5th line, my lord. After that, I arrested the accused Ashok Biswas and produced him to the police station. After that, I submitted a report to the SHO of PS Mahabandar and I chalked out the FIR. My lord, got it? So, Exhibit 4 happens to be a report. This is a formal based on which an FIR was chalked out, which is reflected at
Page 33.
yes, page 33. Now, my lord, will be having that lower court records, my lord.
Yes.
My lord, may kindly see what is Exhibit 4 because it has been translated. It's a translated version, my lord. On the top, it has been written as report. Then it's a Hindi version, my lord.
Yes.
So this particular thing was the document based on which an FIR was chalked out. My lord, why I say that this document is a fabricated document and it's an afterthought, my lord, may kindly come to page number 32.
Yes.
The last line may kindly be read, my lord. The FIR number 104 of 2009 dated 2510 under section was registered in the police station. How can he say if it is a written complaint based on which an FIR was chalked out, then how can he in his complaint say that an FIR was chalked out? My lord, got it?
Yes.
At the time of giving the complaint, I will definitely not be in a position to understand as to what is the FIR number. But the complaint, what he has given itself indicates that he has mentioned the FIR number also in this. So this was the document that was prepared at a very later stage. Now again, I am coming back to page number 3, my lord.
Yes.
Again, coming back to, because it would make everything clear. I arrested the, again, for the, again, I'm reading it, my lord. I arrested the accused Ashok Biswas. After that, I submitted a report to the SHO of PS Mahabandar. Then I chalked out the FIR.
Yes.
This is the report marked as Exhibit 4. I filled up the formal FIR. This is the formal FIR, Exhibit 5.
Yes.
Now, my lord, this is the first document that I have shown, which would reflect that there was no written report itself based on which an FIR was chalked out, because the report itself mentions that this is the FIR. Now, my lord, may kindly come to the seizure memo of the contraband article, which is there at page number 30. My lord, got it? Page number 30 reflects the GD number. That is GD number 24 on the top, my lord. GD number 24 dated 25/10/2019 and the timing is also given.
1805.
1805 hours, because the seizure was effected at 1920. On the top, it is reflected that the GD number is 24 dated this. Now, my lord, may kindly come to the FIR. How they have manufactured, it will be very clear, my lord. Now, my lord, may kindly come to the FIR. FIR column number 3, general diary reference. General diary reference indicates that GD number 1 dated 25/10/2019 and the timing is 1955. How is this possible, my lord? Kindly see here, same day, the GD number is 24 and it is at 1805 hours. Then how will the GD number become GD number 1 at 1955 hours? My lord, if we go by the FIR, then the subsequent GD number, which is reflected in the Panchanama seizure list, it should be not before this 1955 hours.
Yes.
It should be always after, whereas here they have shown it as 1805 hours. Am I clear, my lord?
I understand.
Yes. So this again is an afterthought.
Yes.
Now, my lord, may kindly come to 313. Now, my lord, question number 2 and 3, my lord.
Refer me the page.
My lord, at page number 18.
Yes.
Now, my lord, it is question number 4 I am reading, my lord. It is evident from PW2 and PW3, that is the independent witnesses, that they are the independent witnesses, and in their presence, cannabis was recovered from the sack which was carrying by you. In their presence, a notice under section 50 was also served. They put their signature on the seizure list and they identified the signatures. They stated that from your possession, one sack was found, and from one sack, one fishing net, and another packet was found. On opening the said packet, one packet 10 kg of ganja was recovered and another packet 5 kg of ganja was recovered. Then you are arrested and produced to the court. Now, my lord, may kindly come to the evidence of PW2.
I understand. Yes.
He has never stated anything, whereas these were the questions that was put to me. PW2 and 3 has never stated about any notice served, any contraband article seized, nothing. They have not even stated about the weights, whereas during the 313, the learned trial court has put this particular question to me.
Regarding 10 kg and 5
Yes, 10 kg, 5 kg, notice, 2 bags, cannabis, these things were never said. Now, my lord, this was the sole reason. Because of the discrepancies in the general diary, the GD entry records was not seized. Now the Malkhana register where it is supposed to be kept, those Malkhana registers itself were never brought before the court. It was never seized, nor the person in charge of Malkhana was examined by the IU during the course of his investigation to establish that the contraband articles, until the same was sent to the FSL, it was lying in a foolproof manner.
Yes.
Now, my lord, I am just placing, because yesterday, my lord, I had placed one judgment. Subsequently, I had gone through. that indicates, that is, yes, regarding FSL. No, because there were two divergent views, my lord. Yes. This particular, it's Delhi High Court, Athar Singh. आपको यही दे देता हूँ मैं 1940 1994 DRJ 65 page number 30. Now, my lord, here Athar Singh versus State Administration. ATTARSINGH. My lord, may kindly come to paragraph 15, my lord. Paragraph 15, my lord. Learned counsel for the appellant has submitted that a perusal of the report. Paragraph 15, my lord.
Yes.
Learned counsel for the appellant has submitted that a perusal of the report makes it clear that it is a report by Shri C.L. Bansal, Senior Scientific Assistant, Central Forensic Science Laboratory, CBI, Lodhi Road, New Delhi. And that Shri C.S. Bansal is not an officer covered under section 293 of the CRPC. And thus, this report is not admissible in the absence of the aforesaid officer being examined in the court. He has thus submitted that the report in question cannot be read in evidence. And in the absence of this report, there is nothing on record to prove that the recovery alleged to have been made by the police from the appellant was that of opium. And on this short ground, he is entitled to be acquitted. He has placed reliance on the judgment Hiralal, this thing, my lord. Learned counsel for the respondent has, however, submitted that there has not been any objection by the appellant before the trial court where the aforesaid report was exhibited, and even thereafter, in these circumstances, it is not permissible for the appellant to raise such an objection in this court for the first time. Reliance in this regard was placed, Phul Kumar versus Delhi administration. In order to appreciate the aforesaid submission, the learned counsel for the parties, it would be appropriate to quote section 293, my lord.
Yes.
Reports of certain scientific experts. So these were the persons.
Yes.
Now, my lord, para 4, 293(4). Any chemical examiner or assistant chemical examiner to the government, the chief inspector of explosives, the director of fingerprints bureau, the director of Hafkin Institute, Bombay, the director and deputy director and assistant director of CFSL lab or state FSL. State and central forensic science laboratory, there are only two persons. That is director, deputy director and assistant director. Chemical examiner and assistant chemical examiner were to the government, not to the FSL.
Yes.
They were to be appointed by the government. Now, my lord, may kindly see who is the person who has given
Senior scientific officer.
Yes. It is at page number.
Page 45.
Yes, page 45. For page 46, my lord. It's given by one senior scientific assistant, assistant chemical examiner of FSL. That is state FSL. Now these names are not there.
Assistant chemical examiner.
Examiner to the government, not from the FSL, my lord. For the FSL, only director, deputy director, and assistant director is there.
Okay.
My lord, got it? Now, my lord, again coming to the judgment. A bad reading of this section makes it abundant because in our case, in this case also, it was senior scientific assistant chemistry CFSL. But because he was not director, he was not deputy director, so he was not treated to be a person who was coming under the purview of section 293, subsection 4. Number paragraph 17, a bad reading of these sections make it abundantly clear that the reports of chemical examiner or assistant chemical examiner to the government, director of so-and-so, deputy director, assistant director of CFSL or state forensic are admissible pass without they being formally proved by a person who has made the same. However, a discretion has been left with the court to summon and examine any such expert as to the subject matter of his report, if it thinks fit. C.S. Bansal was only senior scientific assistant chemistry and thus not covered by any of the categories of these experts under section 293 subsection 4. May kindly come to para 19 and 20. I'll straight away come to para 20. Already as discussed, C.S. Bansal is not an officer covered under section 293 of the CRPC and thus his report could not be tendered in evidence by the IO, which was done in our case. Since it could not be read in evidence without being proved by a person concerned, I find no material on record to hold that the recovery effected from the appellant was that of opium. There is no doubt that the witness claimed that opium was recovered from the appellant, but no material on which it could be said that it was opium. The only material evidence in this regard could be the report of CFSL, which is not as admissible as discussed above. It is the cardinal principle of criminal justice, the benefit of doubt has to be given to the accused. Now, my lord, the second judgment with regard to non-compliance of section 42, that is not reducing the secret information in writing, nor sending the said secret copy of the secret information in writing. For that, my lord, I am just placing it. Yes. Now it is Supreme Court of India, State of West Bengal.
Reference there, okay.
Yes. Supreme Court of India, State of West Bengal and others versus Babu Chakravarti. My lord, may kindly come to page number 5, my lord.
Yes.
We have given our fourth paragraph, my lord, from the top. We have given our thoughtful consideration to the submission made by both the learned counsel appearing on either side of the fact. In the instant case, the respondent was charged for the offence under section 21 for illegal possession of 3 grams and 25 morphine, which was commonly known as heroin. The case of the prosecution was that additional SP received a secret information, and to work out the secret information, he along with so-and-so went to the house of the respondent and conducted the search of the accused. What is important to note is that the information was not taken down in writing as required under law and as rightly contended by the learned counsel for the respondent. The search was conducted at 9:45 p.m. after sunset and before sunrise was without complying the provisions of section 42(1), 42(1) and the provisions of section 42(1) and section 42(2) is reproduced here and there. My lord, section 42, my lord. Kindly come to the first same page, my lord, section 42. If it is between sunrise and sunset,
Yes.
then
very
it
much.
is not required.
Yes.
But if it is after, no, my lord, next page, my lord, third paragraph, provided that if such an officer has a reason to believe that search warrant or authorization cannot be obtained without affording opportunity for concealment of evidence for escape of the offender, he may enter or search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the grounds of belief. Here the grounds of belief has not been recorded. There was no authorization, no warrant. The raid was conducted after the sunset, that is 19-20 hours. On that day.
Now, in this case,
Yes, my lord.
there is a judgment. In the public place, it is not required.
Yes, my lord.
Yes.
In the public place, it is not required, my lord. I'll come to that place, that thing also, whether it will be termed as the public place or not. I'll come to that also, my lord.
So today I have no time. So tomorrow can be.
My lord.
Tomorrow.
Monday,
No, tomorrow let him finish. Tomorrow.
Monday I'll reply.
Yes, Monday.
Because I'll get an opportunity to repeat
Yes,
all
yes.
what my learned brother has taken.
Tomorrow.
Tomorrow. Matter not in let the matter is listed on tomorrow.